Hi everyone, this is the Rationally Based Perceptions crew here. I'm Alex Kukalici here with Matthew Covert and Daniel Krepsch. You obviously would hopefully know who we are depending on how far in the future this is. We'll be talking about Rule 602 today. It's the rule talking about lack of personal knowledge and the rule from which speculation is derived. If you don't know what any of that means right now, if you're a new member, don't worry. It's a pretty simple rule. One that has a few added complexities that show themselves later on over the course of your career and over the course of a year, but simple to understand, certainly on its face. It's nothing like character evidence if you just watch that video, so we should be moving pretty quickly. I'm going to throw it up to Dan to start reading the rule, and then we'll start discussing it from there.
Okay, Rule 602, a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove that personal knowledge may, but doesn't have to, consist of the witness's own testimony. This rule is subject to Rule 703 relating to opinion testimony by expert witnesses. So
I think you can, for the purposes here, we can just drop that last sentence. When we talk more in depth about the expert rules, we'll delve into what it's talking about there. But Dan, I just have a question for you. What's an example of something that a witness might not have personal knowledge of? So I guess give us an example of a witness in a trial where they don't have personal knowledge enough to testify to that fact in trial.
So to take this, the current case, the Duran case, to have the victim's parent, Andy Allen, talk about what happened.
Andy Park, scrub.
Sorry, excuse me. Wow, Andy Park. Talk about what happened in the Parks' home when the Parks weren't there. For instance, when the murder happened, the Parks weren't in the house. Andy Park has no knowledge, no personal knowledge of what happened in the house when he wasn't there, so that is a lack of personal knowledge.
What are some ways that he could acquire that personal knowledge? Does he have to be there necessarily, or are there some other ways you could acquire personal knowledge?
I guess he doesn't have to be there. He could be told later on, I guess. I'm not sure what you're...
Yeah, I guess you can be told. You can see video of it later. All of this is subject to, so being told obviously is subject to hearsay rules, which we'll get to, but just other examples of ways people can be familiarized with the situation without necessarily being there. So I mentioned in the introduction to this rule that this is where speculation as a legal term kind of comes from and where it's seen most prominently. Matt, can you talk to us about what is speculation? How does it relate to this rule? Because I'm reading this and I don't see the word speculation anywhere. How is it used? Why is it used? And how is it different than just lacking personal knowledge?
All right. So there's a very important distinction here, and I do something very specific and unique when dividing the two that I would recommend. So put it to you this way. Speculation is part of Rule 602, right? It's inherently ingrained. Here's the difference. Lack of personal knowledge is a state of being. It is not an action. Speculation is an action. It's doing something. So here's the difference. As I sit here, I have a lack of personal knowledge about how guns work, right? I have no idea how guns work. If Alex were to ask me right now, Matthew, how do guns work? He would be asking me something that I do not have any personal knowledge about. If I were to answer that question and open my mouth and start telling you how guns work, then I would be speculating because I'm giving you information without sufficient personal knowledge. So the way I handle this in the context of mock trial is this. When I hear a question asked by the attorney to a witness, when I know that witness does not have personal knowledge to answer that question, I object. Objection, Your Honor. Lack of personal knowledge. The witness does not have the requisite personal knowledge to answer that question, nor has any foundation been laid to assert that. Okay? if I miss the question, or if the question was perfectly fine, but at some point during the witness's testimony, they start saying something that they don't have personal knowledge about, that's speculation, and that's when I object to speculation. Objection, Your Honor, speculation. The witness is testifying about something he doesn't have any personal knowledge of. You don't have to say personal knowledge if you want to really separate the two, and you could just say, objection, Your Honor, speculation. The witness has no idea, whatever, whatever, whatever. So that's how I draw it. Lack of personal knowledge is a state of being to object to the question, and speculation is an action.
So are there any types of answers witnesses can give that might be ripe for this type of objection to be raised? What type of testimony tends to be speculative?
Okay. Testimony about other people's state of mind. So if I'm, I'll use the current case as an example. If I'm Andy Park, right, and I testify, you know, Jesse, he was just always a really angry kid. He was always angry. Well, I'm sort of speculating, right? I don't really know what's going on inside Jesse's head. I may have extrinsic evidence of that state of mind, and I can testify to that. I can say, what's a good, you know, maybe anger's a bad example because it doesn't have a lot of outward. He was always yelling a lot.
You saw him yelling, throwing tantrums. He was always stomping his feet. That goes to show anger without saying that he was angry.
Right. So there's a difference between saying someone is sad and saying you've seen that person cry frequently, right? Because people can cry for different reasons, but nonetheless, that evidence of crying is relevant to proving that state of mind. But you can't just outright say without some sort of authority to go on, oh, this person was sad all the time. So that's a really common type of speculation. Another one I see somewhat
I guess before we move on just about this happens all the time with witnesses making that one step too far type of example that Matt just made, that this witness was angry when I saw him, this witness was upset, this witness was sad. Using this case, you very likely might get a Terry Chapin say that Jesse was so sad after the murder based on whatever these actions are. The fact that he might have a basis for his opinions, that goes to a different rule. The next rule we'll cover, which is where the show derives its name from, actually. Those are separate issues than issues where the witness is speculating. As a rule, these type of instances where people testify to the emotions of other people, they are always speculative. They are, whenever the witness is testifying about the state of mind of another, the law has come down and said that that is not something that anyone can know. That's a hard and fast rule, and it's really very easy to pick up. So we'll talk a little bit later about how speculation, despite its simplicity, tends to go unnoticed in trials. It's very innocuous when said, but can have pretty dire implications if it's allowed to go unchecked. Usually when you point it out, judges will be very in favor of your position and will tend to ask at the very least for a rephrase. So just be careful if you're having any trouble identifying when speculation is occurring. You can pick up on a lot of examples of speculation just by being alert to when witnesses are testifying to the emotions of other people, because there is a very hard and fast rule in the legal community that type of testimony is always speculation. And that's at the very least a good place to start. Before you get into more examples, and Matt is going to go into a couple more examples of stuff that could be lacking personal knowledge or speculative, depending on how you want to phrase it.
So one example that immediately comes to mind is from the Danny Dawson case a few years ago. And I was set to cross a witness, London Bennett. And London Bennett, for context, sort of lived on the street where the accident occurred, and she saw the accident happen. And at some point, this was against Rhodes College at the UGA tournament, and the person playing London Bennett said something to the effect of, the car was going about 55 miles an hour, and I'm pretty sure I popped up and said, objection, Your Honor, speculation. Now that particular example is sort of a mix of an improper opinion and speculation, but for our purpose they sort of lump together. The witness doesn't know that, right? She is inherently speculating or guessing or estimating based on nothing really of how fast that vehicle was traveling. So anything like that where the witness doesn't know, the witness is rather telling you what they think, usually that's going to be speculation. I can give you hundreds of examples, but it's pretty intuitive, right? If someone is talking about something, not that's fact-based, but that's either opinion-based or something they don't have personal knowledge of, they are speculating. It's one of the most frequent objections in mock trial. It may actually be more frequent than relevance. I would say it's probably less frequent than hearsay, but more frequent than relevance.
Yep.
And it's something you got to be prepared to deal with, and make sure that your direct examination testimony does not have any speculative sounding things in it, because judges hear it, they hear the objection, and they're usually inclined to rule that way. Just because they hear something that's speculative, they're not really inclined to hear your side of the facts. So that would be my recommendation for dealing with speculative testimony, and make sure that when you are doing cross-examinations, you don't ask questions that call for speculative answers. And a common objection to that would be, objection, Your Honor, this question calls for speculation. Based on the question that was asked, the witness doesn't have personal knowledge to answer it. So it's a super frequent objection. It's really important to know. It's really important to avoid doing, but it's also a really important skill to be able to identify speculative questions and answers to be able to throw the other team off their game.
It is probably the best objection to do that. And just talking briefly about Covert's second example, the London Bennett and the seeing the car moving and then estimating its speed example, I just want to be very clear that there's a distinction between speculation legally and speculation as we use it in our day-to-day lives. Namely, in our day-to-day, we broaden the definition of speculation pretty frequently, and it's important to realize that while 602 prevents all speculation, when you have either a rational basis or a scientific backing in making that conclusion is not speculation. So you can guess as to a potential or probabilistic result from a set of facts, and that is speculating by its dictionary definition as we use it, but that is not the legal definition of. So if you, for instance, if London Bennett, this person who was witnessing this cargo, was an expert and could tell by the rotations of the tires and the marks left on the road and the time at which the car left the field of vision, or had some sort of backing for that opinion, then even though he is guessing and does not have a specific knowledge of what was going on in the car to say definitively that it's probably the case. He's allowed to do that as not speculation. That's kind of what the last half of 602 is going to, the part that said this rule is subject to the provisions of 703 that we said to skip. I just wanted to mention that while that example was live, just to be clear that not any sort of talking about probabilistic outcomes is speculation under the rule. Those are edge cases. We'll talk about them even more under 701. It's the reason I hold the opinion that the objection Matt just made in regards to London Bennett is better served as an improper opinion objection. It is speculation and improper opinion. But to avoid this distinction, it's good to have an idea of why the two are different and when the two are different. So I just wanted to make sure no one was confused by that and going around objecting to experts or people with some basis for their knowledge, objecting to probabilistic conclusions like that.
Speculation is the most frequently missed objection in mock trial. You could watch a round of the best teams in the country, and I've been in those rounds, and speculation is missed all the time. Witnesses speculate all the time, and the objection is missed so frequently. I don't know why. Maybe you're not listening carefully enough. I'm not sure. I've been guilty of missing it as well. But it's really important that you try to catch it and take advantage of it when you can, because there are not a lot of strong responses for it, and it can throw the flow of the other team's presentation off, which is always what you're trying to set out to do.
For reference, a tournament pretty late into fall semester last year with a team I was very proud of, an incredibly strong team with many members who eventually ended up on Garnet. I kept a tally of all the speculation objections that were missed over the course of a single weekend, 4 rounds at a tournament. My end tally was 26, and that was sans me as an attorney, because obviously if I missed any, I wasn't really paying attention to counting my own. So 5 attorneys over 4 rounds missed 26 speculation objections. That's massive. Catch 12 of those, and the outcomes of even that tournament could be wildly different. So, and that was with a very talented team, people who understood evidence, people who, like I said, eventually ended up on Garnet by the end of the year. So speculation happens all the time and is very easy to miss. So be on alert. I think pretty much that we're done with speculation there. Do either of you have anything to add before we wrap this up?
Nope.
Nope.
Okay. Thanks for listening, guys. Next, we'll be talking about improper opinions and opinion testimony generally with Rule 701. Thanks, and we'll see you then.